G'day, Ben. It's Chris Titley here, mate. I looked at your LinkedIn yesterday and saw an update in regards to a new Australian Fair Work Commission decision ruling that a Filipino worker remotely employed by an Australian company was actually classified as an employee, not an independent contractor. I'm interested in your thoughts from an industry point of view and some reactions to this.
Yeah. Hi. It's an interesting one, actually. Can't say that I'm terribly surprised, and I don't think it's necessarily a bad thing. Um, just probably to summarise it, the Australian Fair Work Court has basically ruled in favour of a worker in the Philippines to be entitled to uh, basically the unfair dismissal laws here in Australia, even though they're employed remotely in a foreign country. Haven't been to Australia as far as I know, but they're working for an Australian company. The company had them on a contractor basis, or so they thought. However, after reviewing the agreement, it looks as though they are classed as an employee under Australia's employee versus contractor laws and criteria. So, yeah, I think it's an interesting one in that there are a lot of new BPO companies that have sprung up in the last few years where they don't have an entity in the Philippines and they're operating as an entity in Australia, which is fine. But they're contracting staff directly because obviously they don't have the legal right to employ people in the Philippines either. So I think there's probably a bit of headwinds on the horizon for companies like those where they're contracting as well. So they've opened themselves up to be exposed by the Australian law regarding Australian employees. And I think the second one too is companies that go direct and contract directly. Staff in any country. It doesn't have to be the Philippines, but any country. I think they're also exposing themselves to some legal risk on that side as well.
So, as an employee, you're in Australia. Then you're subjected to Australian laws, which includes things like healthcare, retirement benefits, holiday pay, etc. But obviously, if you work with a BPO that's registered locally, then the local laws apply.
Yeah. So basically, for us, for instance, we have an entity here in Australia. We have an entity in the Philippines. It's a wholly owned subsidiary. So all of our staff are contracted directly under that subsidiary. So they receive local benefits, they receive their retirement fund, their savings, they receive healthcare, and basically they're contained in that marketplace where the laws have been built to suit that marketplace. And in Australia, we have our own laws here to suit our marketplace as well. So I think, trying to blur those lines has left people in some legal grey area. So yeah, I think definitely if you are looking to hire people remotely offshore, then yeah, probably safest way to do it at the moment is to engage with a company that has either an EOR, so employer of record business on the ground, or a BPO, a business process. Yeah, so I'd do that because I think otherwise you just really are leaving yourself open to the interpretation of the law under different courts, which, as I said, pretty legally grey.
Thanks, Ben, for the update. Really appreciate it.
No worries. Happy to help. See you, mate.